Well, good morning. Thank you for joining us. Well, I mean, everyone is concerned about Anambra. We used to say in the past, it shall be well with Anambra. I think we've reached that point again where we can say it shall be well with Anambra, particularly as the preparations, the jostling for the November 6th election, which is supposed to be a special election. That's the first time INEC will be rolling out its new set of polling units. But here in Anambra, we already have a case, a litmus case, far ahead of the elections. As someone who is chairman of the Committee on Election Matters for Anambra Professionals, can you help us make a sense of the confusion, the imagined confusion, and where do you think the fault lies? Is it with INEC, or is it somewhere else? Could it be the candidates themselves who are at fault?
Yeah, the whole situation is quite sad and very, very embarrassing because the guidelines are clear on how to conduct primary elections and what parties ought to do and how to do it in compliance with the laid down rules and regulations guiding the conduct of primary elections. But unfortunately, that procedure has either been neglected or been overlooked or been ignored or outrightly and intentionally manipulated in order to lead to certain kind of controversy and crisis that have actually engulfed the political landscape of the states known as Anambra, where I also hail from. So it is something very, very pathetic. We are seeing conflict of laws, conflict of orders, conflict of rulings, and conflict of interests over the conduct of the primary elections in the states. For instance, what transpired in the APGA, All Progressive Grand Alliance, where two candidates are jostling for who is the rightful candidate to occupy that seat. Witness a scenario where a court in Jigawa State gave a ruling with respect to what transpired in Anambra State. And then that caused a question, the issue of territorial jurisdiction, whether a court in Jigawa State, by whatever means, has the capacity, has the legal right to determine course of action that arose in Anambra State. That issue also borders on what the law says with respect to territorial jurisdiction. Because in Nigeria here, we have witnessed several occasions where aspirants and litigants decide to go into window shopping, jumping from one court to the other just to get an order, no matter how horrible, no matter how illegal it might be. Because in most cases, they conceal the true facts of the case before the court. Mostly, we usually somehow blame the court by giving all these conflicting orders. But in most cases, courts are bound by what is before the court. The exhibits, the issues, the arguments, the pleadings, the affirmance before the court that will guide courts on arriving at whatever decision. So while we are trying to blame the courts, in most cases, we heap most of the blames on the litigants that by way of their action conceal vital facts of the case before the court. At the Jigawa court, for instance, is a state high court. And the person that instituted that action there is one Alhaji Garba Saliu against APGA and the other candidates. And then he didn't disclose some facts, and he was the deputy chairman of the factional APGA leadership. And he instituted action there against the leadership of APGA that the chairman of the factional APGA, Mr. Judo Keke, has been, Njoko rather, has been removed. And Mr. Judo Keke, the deputy South, has also been removed. That the court should uphold him as the authentic chairman and thereby nullifying whatever exercise the other party, the other faction, they were not even a party to the suit. Whatever exercise they have embarked upon in Anambra State, they are in Oka, and the courts there granted that granted the prayers, not just validating him as a chairman that he never contested, but also nullifying the activities of the other party led by Okoye, the authentic chairman of the ABGA candidates there. Okoye. There, you look at it, but for the fact that courts cannot descend on the arena of litigation to begin to ask questions, but we're also saying that courts should involve in due diligence, and there's what is called application of multiplicity of actions. Before you file an action, you have to deposit an affidavit that there is no pendency of such action in any court of law in Nigeria. I don't know where they observe that, and that's why you now see that judgment coming from there, satisfying Umoji as ABGA candidate, as against the other election that was held in Anambra State, where former central bank governor Soludo emerged. Then for INEC, INEC has the law that provides that INEC must monitor every election. INEC must be involved in any election, primary election, for it to be valid. Then the question now is that, did INEC monitor all those elections? Has INEC been monitoring various elections? Have they been monitoring one election, primary election, and at the same time come to monitor another primary election? Because the law is very, very clear. If election is not monitored by INEC, that election shall, to the extent of its whatsoever, be declared null and void. But are we seeing that now? Most of the courts should consider that while determining whether primary election was conducted validly or invalidly. Because if you have to go to the provisions of the section, I will read it, that will show us to guide the public. Section 87 of the Electoral Act.
Mr. Joe Nwokedi, before you read out that section of the Constitution, let's go on a quick break. We'll be back and you'll be able to read that. Glad to have you back. You're still watching the morning show here on the Rise News, and we still have with us Joe Nwokedi, a lawyer and chairman committee of election matters for the League of Anambra Professionals. We're discussing the debacle in Anambra State, in his state, ahead of the forthcoming November 16 governorship elections there. Mr. Nwokedi, please go ahead. We're going to avail us a section of the Constitution as regards the matter we're discussing.
Yes. To start with what the law says with respect to conduct of primary elections, I would like to read to the general public Section 85 of the Electoral Act as amended 2015. It says every registered political party shall give the commission at least 21 days notice of any convention, congress, conference, or meeting convened for the purpose of electing members of its executives, other governing bodies, or nominating candidates for the elective offices specified under this act. So, for any election to be conducted, your INEC must be put on notice of that election 21 days before the election. That was just to prevent reoccurrence of all the anomalies we are witnessing right now. Because if INEC is put on notice, INEC is supposed to ask questions. They're supposed to exercise due diligence that this faction or this group inviting us for this Congress, are they the authentic leadership of this political party? If INEC happens to engage in that diligent action, this issue of factional and non-factional leadership in political parties would have been resolved even before the Congress. And it's worthy to note that INEC attends the Congress. They send their representatives there. This is to prevent a recurrence of all these court cases emanating from primary elections. But now, upon the fact that the law has it clearly spelled out that INEC must be put on notice 21 days before the election, that's to ensure that every procedure is complied with. INEC will still attend that Congress, and they'll still come out and start battling with which political party or which candidate to recognize, which faction to recognize, and which faction not to recognize. For me, these issues will have been resolved before attending the Congress. Let's just go further. That's section, that's 852. It said the commission may with or without prior notice of a political party attend and observe any convention, congress, conference, or meeting which is convened by a political party for the purpose of electing members of the executive of the governing body of the party. That is, before they elect the governing body, the NEC, elections that would determine the real, authentic leadership of the party, INEC has to be involved. But now, INEC is still finding it difficult to recognize the exact, the valid faction, whereas the law says that they must be involved even before the election of these executive officers that will pilot their phase of that party. Where is now the confusion in INEC? That they will be like allowing cause to like move up and down. INEC is also held to be held culpable in all these crises. Because the law is very, very clear. On the roles they have to play, they ought to play, even before the conduct of primary elections. The same INEC is having problem with whom to recognize. Then we go to the section 3, 853 of that same section 85 of Electoral. I said, the election of members of the State Executive Committee or the governing body of a political party, including the election to fill a vacant position of any of their aforesaid bodies, shall be conducted in a democratic manner and allowing for all members of a political party duly elected delegates to vote in support of a candidate of their choice. So my major contention here is that these guidelines have already provided for areas that INEC is supposed to play a role, areas that INEC is supposed to come into play, so as to determine ab initio, at the beginning, which faction is complied with the provisions of the law and which faction that did not comply with the provisions of the law. But we are not seeing that. Let's also go to 86, section 86. I want to read this so the people will know. He said, INEC, the commission shall keep records of all activities of all political parties. INEC shall keep records of all activities of all political parties. These are the things, the duties assigned to INEC, so as to forestall the occurrence of all these anomalies. You can see that INEC is deeply involved in all the matters of every political party. So if blame should be like traced to the root cause of all these crises, it should be sent to some large extent be apportioned to INEC for not exercising due diligence in their duties to ensure that not only that a party leadership will emerge, also a primary that will conform with the provisions of the Electoral Act will also emerge. Okay. So by the time any faction, any mischievous individual might want to play any mischievous role, INEC will also be in a position to say that, look at what actually transpired. But the same INEC will be choosing whom to accept and whom not accept. They now abandon the whole responsibility, the whole task to political parties. That you know that law has already contemplated that there might be inability of the political parties to dutifully and legally discharge these duties, thereby involving INEC, even pre-election to Congress's election to the executive offices, the election before the election to the primaries. Let's go to the primary election now. A7 proper. A7 said that for nomination of candidates to parties, a political party seeking to nominate candidates for election under this act shall hold primaries for aspirants to elected positions. The procedure for nominating candidates of political party for various elected positions shall be direct or indirect primaries. So the law has made it clear that the parties are left with two choices. Either they choose direct primary or indirect primaries. They said a political party that adopts indirect primaries procedure shall ensure that all aspirants are given equal opportunity of being voted for by members of the party. All aspirants. That's the case we have in the APC. I'm sorry you said APC has no issue. APC has issue. There's one Stanley Okeke that just filed action against APC challenging election of Dr. Andy Uba. Court has actually, I talk at the High Court in Anambra State. Court has granted application for Andy Uba and the INEC, other parties, APC, to be served through sustained means. So his own case is also coming up, but court has not ruled, but he has a pending case. The only party that may not have a pending case now is like Labour Party, YPP, and some other ADC, and some other parties. APC is also has a party coming up, filed by one Stanley Okeke, an head of the President Buhari in this present dispensation, who also contested that election. But court has not ruled on that. Because in their own case, they adopted direct election, but people complained that they could not vote. And that procedure, as was enunciated by what I read now, that everybody must be given the right to vote in a direct primary, was not observed. during the conduct of APC's primary in Anambra State.
Mr. Nwokedi, some people will disagree with you to say that you are blaming INEC largely for all of this and wonder why the internal democracies of political parties shouldn't be held responsible for all of this. INEC, yes, monitors, but they will say they don't conduct and they can't dictate to the political parties what they should do. And they're also bound by the Constitution to obey court orders. So should the political parties decide to cancel their ward and local government congresses, state congresses, because of the decisions from the top of the party, the NWC, how do you then blame INEC for such decisions when it ends up in the courts? But talking about the way forward, INEC at the moment seems to be at the mercy of the courts. But we also know that the conduct of the elections, the schedule of activities is time-bound. What are the likely scenarios to play out in the Anambra elections? Do we see a repeat of the Zamfara elections, the Rivers State elections playing out in Anambra State? What do you foresee happening?
The matters are before the courts. I think what may happen might be a scenario that played out in Rivers State between Amechi and Domain, because the law is very clear that it is a political party that sponsors candidates. None of the candidates contested that election as an independent candidate. They were all sponsored by political parties. And the worst case scenario may be like the name of the political parties will be at the ballot boxes, while courts are left to determine the authentic candidate of the political parties. But the political party might go ahead to contest the election because at the end of the day, a candidate will emerge. And it will be very, very injurious to any party that may have spent resources, spent their time and everything to conduct their primary, and at the end of the day, they will not be given opportunity of participating in the election. And by the time court might determine the authentic candidates for the elections will have been conducted and gone. So I think the best approach to this issue is that while parties are trying to sort out their issues in courts, INEC should do well to put the names of political parties, which we normally see in the ballot boxes, not the individuals, and go ahead with the elections. Parties can still contest the elections, parties can still submit to the elections and do their campaigns while the matters are going on in court. And I also want to appeal to our judiciary to also, although the judge may not know what transpired outside what is before the judge in a court, to also look inwardly, to also find a way to expedite action, to have accelerated hearing of all these cases. And then if it warrants giving dates for these matters to be had throughout a whole week, just give them Monday to Friday, give them days, Monday to Friday dates, so that every matter will be dispensed with within the shortest period of time.
Okay.
The Chief Judge of the High Court might give an order for accelerated hearing of all the pending political cases in any state after primary elections. Procedures of court might be amended to give a timeline within which all the issues arising from primary elections will be resolved. Like within 20 days of conducting the election, all issues should be resolved. And right of appeal also, because some of them might want to appeal up to Supreme Court. Right of appeal should be reduced to a certain kind of high court or appeal court and not Supreme Court.
Mr. Nwokedi, two quick questions. Number one will be, what's your take on this idea that people now shop for different types of jurisdiction? Allah going to as far as Jigawa and the likes to get an high court. No, that's one. That's one. Secondly, now, you made a point. Yes, it's the political parties that nominate a candidate. Now look at that vis-a-vis what is happening in Zamfara State now. That the mandate of the PDP has been pushed to the APC because of defection. Just reconcile those 2 points for me.
No, they was transferred in Zamfara State was because I'm not saying that the argument is that political parties will not participate in the election because they don't have a candidate. My contention is that they will participate if at the end of the day, when all issues before the court are resolved, and there is that discovery that they did not comply with the proper procedure for electing the person that eventually became the standard bearer of the political party that eventually won the election, that person might go. That person might go. But not having a party fielding a candidate or participating in the election is where I'm saying that invariably the masses that might have wanted that political party to lead them might be disenfranchised, and that would be totally wrong. So what played out in Zamfara was, at least there was a governor, the former governor was there, before courts now nullified the whole issue and said, look, the person that came second is the person that came first was not validly nominated. The person that came second should do that. And the INEC should also desist from not making it impossible for a political party to field a candidate. Because we cannot, just because of a recalcitrant attitude of an individual, then deprive a whole party, to some extent, electorates that might want that party to rule them, the opportunity of having their candidate at the polls. So while we're looking at strictly to issues of law, legality and issues of law, we'll also consider the intention and purpose of democracy, which is the voice of people prevailing, having government of the people, by the people, and for the people. So that we don't make everything to become legalistic. Electoral democracy is not a rule of the courts, it's the rule of the masses. So we should not push everything to the courts, and courts will not be the one that will determine who becomes a governor or not. No, that is very, very wrong. In as much as the procedures might not be strictly followed, but then the burden of electing people should not be pushed to the courts. That was what we saw in Imo State. Where court elected a person instead of the masses electing someone. Second question they asked me about jurisdiction. We have factors that determine.
Time. If you can be very brief, there is still a question I would like to ask you. So go ahead, but be brief. Go ahead.
So the issue of jurisdiction, court actually stated what like a shopping of cases outside all over the whole federation. Before you can, before you do that, there are what court formulated a policy on the case of Oshomole versus Saliu. In that case, so-called Justice Onyemenam of Appeal Court ruled that for a court to have a jurisdiction in any matter, the defendants, the applicants must reside within the place where the cause of action took place. If it is Noka, wherever the person is residing, court there might have jurisdiction. The defendant, where the defendant or the appellant or not applicants carry some business, and then the cause of action where the cause of action emanated from. Then cause of action now emanated from Anambra State. The applicants, they don't reside in Jigawa State. And then they don't, I'm not even sure they do business in Jigawa State. So when you look at people moving, because some people always believe that the cause in the states can always be maneuvered by the governor. But that is not an issue. Laws must be followed. If any cause of action commences in any particular place, that is where you have to institute that action. And you can't institute an action at Jigawa State and another action in Anambra State. And the worst case in this issue that they are court of coordinate jurisdiction. Okay, look at the case of Jigawa State is still pending now. It has not been vacated. And the Anambra State High Court has also had a matter approving Soludo as authentic candidate. Right now, APGA has 2 candidates approved by the courts. The one in Jigawa has not been quashed. Then the one in Anambra is still subsisting. Now, which one is INEC going to obey? So, and they must go on appeal. People should know that state high courts and federal high courts are courts of coordinate jurisdiction.
Well, Joe Nwokedi, I'm not too sure we've been able to exhaust all the issues. You spent most of the time blaming INEC. I wanted to throw questions at you. You don't worry. Don't worry. I heard you very well.
Political parties are also culpable.
Because
are not exempted.
Yes, so I wanted you to broaden the conversation, but it's okay. We've been able to take just what we can take. Thank you very much for joining us.
You're welcome.
Thank you.